Hi friends, today I am going to review the book, Protecting Your Company's Intellectual Property, A Practical Guide to Trademarks, Copyrights, Patents and Trade Secrets by Deborah E. Bouchoux. Intellectual property. You name it. What's in a name? Well, the next time you pick up a can of Coca-Cola, notice the logo. The Coca-Cola brand, one of the most widely recognized logos in the world, is worth an estimated $30 billion, a bedrock asset in the company's intellectual property portfolio. In most instances, intellectual property assets are lost if they are not actively monitored and protected. Many executives fail to protect their company's intellectual property because they don't understand what items are in that category. Your customer lists, your products' names and logos, your list of potential acquisition targets, your employees' know-how, your marketing materials and your marketing projections are all protectable intellectual property. While you easily can determine the value of tangible assets, physical plant, machinery, inventory, etc., the value of intellectual property can be elusive. But before you can capitalize on these assets or protect them, you must identify them. The four main types of intellectual property assets, which often overlap, are trademarks, copyrights, patents, and trade secrets. Trademarks. The average consumer may encounter more than 1,000 trademarks a day. Trademarks include all the names, symbols, designs and slogans a company uses to identify its products. A trademark differentiates your goods from those of a competitor. Rights to trademarks do not hinge on registration with the government, although registration provides certain advantages. If the Grand Auto car dealer fails to register its trademark, it still enjoys legal protection against another company using that name in a reasonable geographic area. However, registering the trademark could offer nationwide protection against similar uses that might otherwise confuse the consumer. Variations in trademark registration include service marks, which represent services and not tangible products, e.g., United Airlines, R, certification marks which denote quality review, UL, R, for underwriters, laboratories, and collective marks, which protect the names of groups and associations, American Bar Association, R. Intellectual property is legally fragile, meaning that once an owner's rights are lost or compromised, it is extremely difficult, if not impossible, to recover those rights. You need federal trademark registration if you use your mark in interstate commerce. You can file an application with the U.S. Patent and Trademark Office and pay a fee. Thereafter, the PTO requires periodic filings to prove that you are still using your trademark, since marks that are not being used are available to others. Unlike copyrights, however, trademarks do not expire. Once you register, you can place the R symbol on your product, although you don't have to use the symbol to preserve your intellectual property rights. A trademark cannot be so generic, soda, lumber, that it represents an entire class of products. When you want to know if a trademark is available, you or your attorney can hire a company that specializes in trademark searches. Search the PTO website or conduct a trademark search at the PTO offices in Arlington, Virginia. Copyright. The copyright protects creative works, including literature, music and motion pictures. It gives the owner the exclusive right to reproduce, distribute and display the work. Advertising copy, marketing brochures and even software programs can be protected. Copyright protection exists from the moment a work is created. Registration with the U.S. Copyright Office is not required, although it carries certain advantages. A registered copyright lasts for the author's life plus 70 years. General unfair competition statutes, both at the federal and state level, ensure that conduct in the marketplace is based on standards of ethical business conduct. Generally, the person who creates a work owns it. The exception is works made for hire. When a work is made for hire, the employer rather than the employee is considered the author and the term of ownership is 95 years after publication. Copyright protection generally covers fair use, which means a copyrighted piece can be reproduced, distributed or displayed only for criticism, news reporting, comment, teaching and research. The Semiconductor Chip Protection Act of 1984 adds protection for the mask stencils used to create semiconductor chips. You can conduct some rudimentary copyright searches through the Copyright Office's website. Patents. Anyone who invents something new, useful and non-obvious can obtain a patent. Patents have been filed on objects as diverse as the Wright brothers airplane, the safety razor and Amazon.com's one-click online ordering system. Unlike trademarks and copyrights, however, patent rights only pertain once the patent has been issued. The patent is essentially a government grant providing the owner the exclusive right to sell, manufacture or use the invention. The most popular, 90% of those filed, patent is the utility patent, which protects new inventions and processes. Design patents protect new inventions and ornamental designs, and plant patents protect new plant varieties that are asexually reproduced. Patent infringement can carry a steep price, including triple punitive damages. Trade secrets. Trade secrets are any valuable information that gives its owner a competitive advantage. Virtually any type of corporate information can be protected. The protection comes into being as soon as the information exists, and it lasts as long, sometimes forever, as the owner makes reasonable efforts to keep it secret. No government registration is required. Intellectual property lost and found. Make a thorough search of your company to locate and defend your IP. Start by checking 1. Sales and marketing. Look for brand names, marketing support materials, sales kits, advertisements, and slogans. 2. Consider protecting new product names, as well as slogans, PowerPoint presentations and other slides, movies and audiovisual materials. 2. Live sales presentations cannot be copyrighted, but written support materials can be. 3. Human Resources Department. You can copyright your employee handbook and training materials to protect your advantage in retaining and developing employees. 4. Graphics and website. Protect valuable logos, designs and artwork. 5. Make sure the material on your website is not borrowed from any other source. 6. You can copyright the website itself, but include terms and conditions of its use on the site. 7. Review it for any sensitive information that could leak out to competitors. 7. If the site identifies your employees, for example, you could be giving your competitors a recruitment list. 8. Research and development. Consider all the work of your R&D team as trade secrets during the design stage and protect it with patents as it nears development. 9. Remember that patent law only protects new inventions. 10. Once an invention is in public use and offered for sale, you have only 1 year to file for a patent. 11. After that, the product enters the public domain. 12. Engineers should maintain notebooks of work in progress, which can later be used to establish that the work is unique and original. To protect and promote your intellectual property portfolio, you can 1. Help your colleagues become familiar with the value of intellectual property. 2. Conduct periodic intellectual property audits to locate key assets. 3. Control access to trade secrets. 4. Monitor periodicals to ensure that competitors do not infringe on your trade secrets. 5. Routinely review your website, and those of your competitors, to ensure that the content does not infringe on copyrights. 6. As soon as intellectual property claims arise, retain experienced outside counsel. 7. Consider insurance coverage for alleged IP infringement claims against your company. Trademark infringement. What if someone infringes on your trademark? The test used to determine if a trademark infringes on someone else's is whether its use is likely to cause confusion among the public. Proof of actual confusion is not necessary, the likelihood is enough. Intent to infringe also is not necessary, since accidental infringement can be just as damaging. In an infringement case, the main factors considered include the similarity of the trademarks, the similarity of the goods and services offered, the similarity of the distribution and sales channels, the nature of the buyers, are they likely to be confused? How well established and strong the trademark is, and the existence of actual confusion or intent to infringe, which, although not necessary to prove infringement, is naturally frowned upon in court. If your trademark has been infringed, you must enforce it or risk having your rights waived. This requires a civil action in federal court against the party that used your registered mark without your consent. The top 10 copyright myths. These copyright myths are common misconceptions. It is not true that 1. As long as you attribute material to the author, there is no infringement. Attribution may demonstrate that you had no intent to infringe, but without the author's permission you are still liable for infringement. 1. It's on the internet, so it's fair use. Check the terms and conditions posted on the website. 1. If copying its material is prohibited, using it is probably an infringement. 1. Paraphrasing will protect you from copyright violation. Copyright protects against literal and non-literal copying. 1. Paraphrasing can constitute infringement. 1. If you only use a little, it's okay. If the small nugget you infringe is the core of the creative work, infringement has occurred. 1. You own the rights once you own the work. Actually, a copyright owner retains some rights, even after the copyright is sold. 1. For example, you license rather than purchase software, therefore, you are not free to make copies for others. 1. Even without a commercial motive, reproducing several chapters of a book is an infringement. 1. Non-profit use is not an infringement. Non-commercial use is still an infringement. 1. Making a copy for a friend is okay. No, it isn't. 1. Even without an exchange of money, copying a rented video for a friend is an infringement. 1. If you don't know the rules, you can't be expected to abide by them. Not so. 1. Innocent copyright infringement is still infringement. 1. It wasn't me. 1. I didn't do it. Commercial copy centers have been held responsible for allowing students and others to reproduce copyrighted materials. 1. Those who assist in the violation of a copyright and could have controlled the behavior are also responsible. 1. I can play the radio, TV or music CDs for my employees with no problem. That depends. 1. If your company is a certain size, you need a license. The first sale doctrine. Why do software companies license rather than sell you their software? The first sale doctrine in copyright law states that once you buy a book or other creative work, you can give it away or sell it, though you can't duplicate it. The right to sell a patented item extends to the buyer. The first sale doctrine is why software companies license their software to consumers. While it would be absurd to license a book to prevent people from sharing it, passing software about freely would surely affect the market for it. So when you purchase software, you are actually only buying a license permitting you to use it. Several websites operate as intellectual property bazaars where companies can value, sell or license their IP. Takeaways. 1. Intellectual property is one of the fastest growing intangible assets. 2. The typical company's intangible assets will soon comprise 80% of its value. 3. Companies must conduct intellectual property audits to learn the value of their intellectual property. 4. If you don't defend your intellectual property assets, they can be considered waived or lost and, once lost, they are almost impossible to recover. 5. You can enforce your trademarks, trade secrets and copyrights, even if they are not registered with the government. 6. A patent only becomes effective when granted by the government. 7. Patent applications have increased 50% in recent years. 8. Review the terms and conditions of a website prior to copying any material. 9. Copyright laws protect paraphrasing as well as outright appropriation of content. 10. If you attribute material to its source, you show that you lack malicious intent but you are not absolved of infringement. 11. If you enjoyed watching our content and want to stay updated with our latest videos, we'd greatly appreciate it if you could subscribe to our YouTube channel. 11. Your support truly means the world to us. Thank you so much for tuning in and watching.